Hi guys, so this is Raja. For those who are watching this video for the first time, I am Raja. So I have cleared UPSC IFS exam 2019 and I'm basically an engineer from Anna University Chennai. So in this video specifically we will focus on the current affairs for Prelims 2021. So this will be a series of 30 to 45 minutes video. We will be covering the current affairs from last June to this August. Almost more than 12 months we will be covering subject wise. So we will take source the material primarily from PT 365 and other sources like Insights on India. So we will discuss in detail. So we will start today with the Polity current affairs. Let's start the day one of current affairs for 2021 Indian Polity. So I think you will be able to see in the background of the screen what I am reading. So the first topic for our discussion is the basic structure. So I'll tell you what you should focus and what you should not focus, or what you should read very carefully with respect to each and every topic. So for example, starting with the basic structure doctrine, which was in recently news because Sri Keshavananda Bharati he recently passed away. So this case, which was originated in 1972-73, primarily was in relation with acquisition. Government was about to acquisition the land from Sri Keshavananda Bharati, and he approached the Supreme Court as he told that it was a violation under Article 25, 26 and 31. You will be knowing here, I think you will be able to read as well in the background video. So this was the case which was seen as a violation of the fundamental right. So it went to the Supreme Court, and there were different interpretations which were given earlier. For example, if you see this image which is in the background, starting with the Shankari Prasad case in 1961, I have given a mnemonic here, SSG KBC. SSG is Shankari Prasad case and Sajan Singh case and Golak Nath case. Okay, in these three cases, especially in the Golak Nath case, it was told that fundamental rights cannot be amended by the parliament because it does not have the power to amend the constitution under Article 368. So this was given in Golak Nath case in 1967. But then previously it was, you can tell it was in contrary to the previous judgments in Shankari Prasad case and Sajan Singh case. And then further in 1972-73, that is what I have written as KBC, Keshavananda Bharati case, in which the court told that, or you can tell even court repealed what was told in the previous judgment and told that the fundamental rights could be amended, can be amended by the parliament. Okay, any part of the constitution can be amended, even the fundamental rights. Okay, but with the condition that it should not affect the basic structure of the constitution. This you can tell as a judicial innovation, because till now this concept did not exist. Okay, it was not defined in the constitution. It was, you can tell, as a example even for judicial activism. So this was the case here. So in between, after Golak Nath case, once the judiciary has given in 1967 that the fundamental rights cannot be amended by the parliament, then the counter legislations were given by the parliament, like the what I have written here on the side, 24th and 25th constitutional amendment, wherein they told in the 24th that parliament can amend any part of the constitution, and constitution amendment does not come under the Article 13 as an ordinary law, which essentially means that even if it is violative of fundamental right, it cannot be questioned. And in the further 25th constitutional amendment, they told that they took away the power of the judicial review, that is the court cannot review the cases, the scope of judicial review under Article 39B and C. So then after this only after this comes your KBC, Keshavananda Bharati case, in which this provision of removing the judicial review was cancelled or repealed, and then it was told that this is the basic, judicial review is one of the basic structure doctrine, or one of the components of the basic structure doctrine. So with this with the following subsequent judgments, this concept of basic structure has been refined, or the different components to the basic structure were added. Like for example, if you see here, sovereignty of India, supremacy of the constitution, separation of power, secularism or power of judicial review, parliamentary system, rule of law, free and fair election, principle of equality. So all these were added with time, with different judgments. So this was one of the most important historical judgments you can tell. And during this period, this necessitated to understand or created a need here also for us to understand certain judicial doctrines. For example, the doctrine of harmonious construction. Here, the example I have quoted here is the Schedule 7, but still, the example, this you can take even harmonious construction between DPSP and fundamental rights, where one principle of the constitution or one article of the constitution is in conflict with the another article of the constitution. Efforts has to be made to make a harmonious interpretation of one with respect to the other, and that was the first doctrine of harmonious construction. And then the doctrine, these are some of the most important doctrines. Some of them are asked in the prelims with respect to their meaning or applicability. And the second one, the doctrine of prospective ruling. What it means is the any judgment which is given is not only judgment for that case alone, but also it is a judgment for future cases. That is, a particular judgment, any particular judgment can be used as a judicial precedent, or it can be referred to for the future cases. That is doctrine of prospective overruling. Fine. Then the doctrine of pith and substance. This is one of the most important doctrines you can tell, because often we come across this issue of union encroaching upon the state list or subjects, or the states coming into conflict with the union law. So this kind of cases happen. So this doctrine of substance holds that the union and the state legislature should not encroach upon each other's sphere of influence, or they should work only in their areas of sphere. And the doctrine of severability, and this doctrine is very important, or it tries to tell what will happen if a principle is violative of fundamental right. If you could read the last line, it tells that if any principle or any law is violative or inconsistent with the provisions of the fundamental rights, then it shall be considered to be void. Or what it tells that it will be considered that it derives its validity from Article 13 and states that all laws that were enforced in India before the commencement of the Constitution, which are inconsistent with the provisions of the fundamental right, are to be considered or inconsistent to be are to be considered as void. Okay, so this is doctrine of severe. Severe means removing or discontinuing something which existed before. Okay, and doctrine of eclipse. Doctrine of eclipse you will be knowing one is overshadowing the other. So here any law which is violative of the fundamental right is not null by itself, but rather it is considered that it will not be enforceable. It is non-enforceable. Means, let's say a law is violative of a particular article, let's say 14 or 15, whatever the article, then it doesn't mean that it is null. Rather, the article 14 overshadows the law. Means the article 14 is enforced upon the particular law. So this is doctrine of eclipse. And doctrine of laches, which tells that the court will make effort to solve the cases, those who are aware or those who are fighting for their rights, okay, or who are vigilant about their rights, but not for those who are not vigilant about their rights. Means it should take effort for solving the case in which the individual is forthcoming and he is vigilant and wants to solve the case. But there will be some other cases like stale, which are left for decades together. So the court is telling you should come forward for solving the cases in which the individuals are vigilant and are interested in the case. Then the doctrine of territorial nexus. This doctrine means that a law made by the state legislature are not applicable outside the state boundary unless and until there is sufficient nexus between the state and the object. For example, if a state law is made in, let's say, a state of Maharashtra, then it will not be applicable for, let's say, Madhya Pradesh or Rajasthan or Karnataka, any other state. Okay, unless and until, let's say, the crime is happening, let's say the crime is happening in Maharashtra, but the accused are from some other state, any other state surrounding, or there is nexus between different people from different states, then it can be applicable. Otherwise, in general, it is not applicable. These are the general doctrines with respect to the judiciary. We will move on with the outcomes of the Keshwananda Bharti case. So, this upheld the validity of the 24th Amendment, that is, the Parliament can amend any part of the Constitution under the condition that it should not alter or damage the basic structure of the Constitution. And it corrected the judgment of Golaknath case, which told that the Parliament does not have the power or it cannot amend the fundamental rights of the Constitution. Fine. And the second topic, okay, impeachment of the President, which was in news last year, primarily due to the US impeachment case against the ex-president Donald Trump. So the basis of distinction between these two countries will start from the grounds on which it can be done. One, for Indian President, it will be on the basis of violation of Article 61. For US President, it will be based on the treason, bribery or other high crimes. So who can initiate this? In India, it can be done in either houses, while in USA, it can be done only in the lower house or the House of the Representatives. The stages, I have taken a different diagram for your simpler understanding from net. So if let's say this case has to be taken up in the Parliament, this has to be initially passed by any one of the courts. For example, from 1/4 of the members of the House has to sign, and then it has to be put before it has to be given in the Parliament, and 14-day notice has to be given to the President, and then 2/3 majority of them will vote for the impeachment, and it will go to the second house. So here the same case in the case in US is wherein 50% majority has to support in the house in which it is originating, and then once it is debated and then passed with simple majority, the President will be impeached, and then it will be going to the second stage in the next house for removal of the President. So the only difference, almost same from one house to the other house, in US from lower house to the upper house or House of Representatives to the Senate. So in the case of Indian President impeachment, the second house has to pass with 2/3 majority. In US also it is 2/3 majority. Only difference is in the first house or the lower house in the case of United States, which is simple majority in US, 2/3 in 2/3 majority of the total membership, or special majority in the Indian house or lower house or any house which is initiating the proceeding. Fine. So this is with respect to the procedure, and finally after the second house passes, the President will be removed in case of India, and here also conviction and removal from the office. Fine. So we will go on, and the keyword one I forgot to tell you here is 2/3 majority of the total membership, and here it is special majority, 2/3 majority. Fine. We'll move on to the next one. This is also one of the recurring topic, often repeated topic in UPSC Prelims as well. The topic is related to the pardoning power of the governor. So wherein the governor has the power, the President as well as the governor has the power to pardon a criminal who is convicted. Okay. So this is related to the case of the ex-Prime Minister Rajiv Gandhi's assassination case, wherein a person, Pererivalan, his case came to the Tamil Nadu governor for pardoning. So article number 72 deals with the pardoning power of the President. So you can always add the number 89. This is just a simple short code to recall the provision related to the state. Okay, if there is, let's say, 72 for the center President, then it will be plus 89, that will be 161 for the governor in the state. Pardoning power. So the President can pardon the punishment, any punishment against a union law, and even he can pardon court martial or even the death sentence, while the governor cannot do so with respect to the court martial as well as the death sentence, even though he can pardon any other punishment under state law. So there are different powers of the President, different pardoning powers, starting with the simple pardon, which means it's like a clean slate. Your both sentence as well as conviction will be completely removed and absolved. It's like he is born as a new person, like that. And then the commutation is like substitution. You can recall like this: commutation is substitution with the lighter form of the sentence. Like let's say one person is given a rigorous imprisonment, it will be changed to simple imprisonment. Then remission is reduction, reducing the period of sentence from, let's say, from 7 year of imprisonment to 5 year, or 5 year to 3 year. And then respite is like respect for, let's say, a person with unique let's say unique situation, like a pregnant woman in jail or a person with disability, considering their case, that is respite. And reprieve is staying of the execution for a temporary period, especially mostly it's related with the staying of death sentence. And as I have told you, governor can suspend, remit or commute the death sentence, but he cannot pardon the death sentence even though it is prescribed by a state law. It has to, if that is the case, then it has to be pardoned only by the president. Fine. And the pardon difference between pardoning power of US president and Indian president: when it is told that US president is pardoning, it means it is an exclusive or executive privilege that he can pardon anyone. For example, he pardoned the ex-president, US president pardoned the NSA, National Security Advisor. While when we tell it is the Indian president pardoning, it means that it is on the basis, on the recommendation or the advice of the cabinet. That is the cabinet, which includes the prime minister, which advises the president on every issue. Fine. And the next one is the sub-categorization of OBCs. The key important points include: the committee name is Justice Rohini Committee, which was constituted to discuss about the sub-categorization of OBC, which means that, let's say, we have different categories. If you apply for UPSC exam also, you will know that there is categorization like general, OBC, SC, ST, different categories of people. So this is to give, let's say, we have reservation provisions. So in that reservation provisions also, let's say in OBC, certain group of people are always at disadvantage, but those who have already availed the benefits continue to avail the same benefit. So in order to remove such a scenario, okay, so this committee was created to create a sub-categorization. Like, let's say the most underprivileged in, let's say, a OBC or SC or ST can be taken. This is with respect to sub-categorization of OBC. Fine. So this is related with Article 340, which empowers the president to create a committee to study the condition of the backward class people. Okay, earlier, just some numbers, some years, 1980 1980 was a period when Mantle Commission submitted its reports, and 1990 1990, that was the period when the Mantle Commission recommendation of 27% reservation was given. 27% reservation was given to the OBC or the other backward class community. Okay, so these are people who are socially, and you can read here, socially and educationally backward. This is the issue here. So now, in order to implement this in 2016, education quota was created for those who are from the backward community, and this was provided under Article 15(4) of the Constitution, which is related with reservation, as you will be knowing. So in Indra Swane's judgment, this is one of the most important judgment of 1992, which the Supreme Court told that this reservation cannot exceed the 50% of the total number of seats. Let's say if there are 100 seats, you can do reservation maximum for 50 seats. 50 seats should be for open competition. So this was in 1992. So that introduced the concept also of creamy layer, wherein it told, let's say, people from a particular community, let's say OBC, or now at present it is implemented for OBC. If they have a particular income level, let's say they earn above 8 lakh per year, then they should be considered as creamy layer. They should not be awarded any reservation. They should not be considered under reservation. They should come under open category or general criteria. Fine. So this was the creamy layer concept which was given, and which in 1992 Indra Swane case. Fine. So this idea of subcategorization has been repeatedly proposed and repeated number of proposals have been given. For example, the L.R. Nayak committee or a person in 1979, he gave different categorization like intermediate and depressed classes, depressed backward classes. And in 2015, NCBC gave three categorization of EBC, that is extremely backward class, MBC, most backward class, and backward class group ABC. These were suggested earlier. Fine. And this proposals were given for subcategorization already. Now what is the relation or why it is in news? Primarily because the NCBC which is created, which was earlier not existing as a constitutional body, because Article 338 provides for creation of NCSC, National Commission for Scheduled Caste, which also overtook the or monitored the situation of the backward classes. Now under Article 342A and 366 through the Constitutional Amendment Act of 102 Constitutional Amendment Act, we have made the provision Article 342A and 366, which tells about the socially and educationally backward class people, and providing the definition for which is providing the definition for the backward class people which was not otherwise provided. Okay, just remember Article 338, which was the earlier provision for NCSC. Now two articles have been inserted, Article 342A, 366. Okay, and this changes in these two articles was brought by 102 Constitutional Amendment Act 102. Fine. So we will move on. So this NCBC has the power to hear the grievances related to the non-implementation of schemes or provisions related to the backward class people, and the inquiring into the compliance of deprivation of the rights, and it also has the power of the civil code to enforce its decisions. Fine. So this is with respect to NCBC subcategorization of OBC. Fine. The next provision, next concept is the Official Language Act. This has also been repeatedly in news also, and here the Chief Justice has recommended that the vernacular languages should also be used in addition to, let's say, Hindi and English. And there was one more issue also we will be discussing. In Haryana, the lawyers have filed a complaint telling that Hindi should not be imposed. Okay, rather the other language should be promoted. This was also a case. So this Official Languages Act 1963 provides for the languages which can be used for the official purposes. Okay. Under the Act, it has been provided that both English and Hindi shall be used for certain specified purposes, like the purposes given like rules, resolutions, general orders, and notifications. Fine. So this, there is also a schedules, different schedules are there. We will be knowing the 8th schedule. I have a diagram just to show you as well. So 8th schedule is dealing with the scheduled languages, in which we have 22 languages, in which the most recently added were Bodo Dongri and Maithili and Santali, BDMS. That was in 2003 by 92nd Constitutional Amendment Act. Fine. So under Article 344, an official language commission can be created with a chairman and other members as decided by the president. This is under Article 344. So this was to promote, or what is the objective of this commission? To promote a progressive use of the Hindi language, to as to restriction on the use of English language for all purposes, or the languages to be used for any other purposes, and for promoting the use of communication language between the union and the center. These are the provisions which are under Article 344. Fine. We will move on. Then some other important news like relating to the right to protest, as you will be knowing that Supreme Court has clearly told, although Article 19(1) subclass 1A or 1B provide the freedom of expression, freedom of speech, or right to assemble peacefully, but there is no right to strike. You can express yourself, you can demonstrate your demand, but you do not have the fundamental right to strike, and it has been clearly given by the Supreme Court. This was in relation to the farmers' protest and other protests which were going on in the last year. Fine, and we will move on. So the functioning of the parliament, the how does it function? If you could see in the image, the first hour is usually the question hour, followed by the 0 hour, and then the break, and then the legislative business. So the question hour was recently cut short or removed primarily because of the COVID pandemic situation. Okay, so the first hour of the parliamentary session is question hour, wherein questions can be asked to the, let's say, the ministers, and holding them accountable for their actions. And there are different types of questions which can be asked. For example, starred questions means, let's say you write a question and put a star, telling that we need an oral answer. If it is starred question, there is need for oral answer only. If it is unstarred, then you should give in writing the answer for the question. And then short note question, and which is asked orally, okay, and which is the first item on the agenda if there is no question hour plan. And the question to the private member can be asked. For example, if a private member has proposed a bill, let's like say there was a private member who proposed a bill for protecting the rights of the transgender, then you can ask to the questions to the private member, half an hour discussion, wherein with speaker's permission, in case if it is not satisfied, if it is not satisfied with the starred or unstarred question, you can always go for a half an hour discussion. Okay? And the basic condition is you should give a 15-day prior notice, and only 5 questions per person will be allowed per day. That is the limitation. Fine. And the 0 hour is nothing but the hour which follows the question hour. It starts around 12 noon. Typically, it mostly gives details about the, let's say, the important bills, budgets, and other places which takes place after the 0 hour. Fine. And this 0 hour, okay, it always gives a room for the members to raise important issues with giving prior notice to the speaker. Fine. And this has not been mentioned in the rules of the rules of procedure, but okay, so the 0 hour, okay, is an Indian parliamentary innovation. Okay, and unlike question hour, which is mentioned in the rule of procedure, the 0 hour is not mentioned in the rules of procedure. Fine. Okay. Then we will move on. So the Parliamentary Standing Committee, and this I would suggest for those who are viewing the video, you must go through the Parliamentary Committee separate chapter in the Lakshmikant. One or the other question will come in every year. Okay, due to pandemic situation, the tenure of the parliamentary committees have been affected. So whether they should be reconstituted or their tenure should be extended, this was the discussion recently. So parliamentary committees, as you will be knowing, there are 2 types of committees: standing committees and ad hoc committees. Standing committees are permanent in nature and they are constituted every year and they work on a continuous basis. Ad hoc, by term itself, it is temporary. So it is created only for a particular issue or a particular task, and then it will be dissolved. Fine. So there is, although the constitution repeatedly tells about the parliamentary committees, it has not clearly told about its constitution or its members or its nature or tenure. Fine. So the main objective is, as you will be knowing, parliamentary committee is to study any legislation or anything which is brought before this in detail, to scrutinize the government action, to, let's say, enhance the opposition, to play a very dominant role against any government action, or to scrutinize and criticize the government action. This is very helpful to study any proposal by the government in detail. Fine. In general, there are 6 categories of standing committees, as you can see in the screen behind me. Okay, financial committees, departmental standing committees, committees to inquire, committee to scrutinize and control, committees related to day-to-day business, and housekeeping committee. 6 major categories of committees. Fine. And as you will be known that the parliamentary committees are recommendatory committees. That is, it is not bound on the parliament or on the government. It's just going to be a recommendation to the government. Fine. Next one. The Office of Profit issue. This has repeatedly been news because starting from the recent few years back, the case of Jaya Bachchan, she was disqualified on the basis of this provision of Office of Profit, and the Supreme Court also upheld the decision of disqualification. But still, it is not told that what is Office of Profit, or Office of Profit is not clearly defined in the Constitution. So the Supreme Court has asked the centre's response of amending the Constitution to clearly tell what is this Office of Profit. Because if a person, a member of the Parliament or a member of legislature, is occupying an office of profit, by which what it means is, let's say here it has been clearly given. If you see the case here, in the lower part of the page, it has been given in the Swevenroy case that 4 broad principles will define whether it is a office of profit or not. 1. Whether government exercise control over the appointment. Okay, appointment or removal or performance. 1. Control, government control. Then second, does the person receive any remuneration like salary, money or anything? And in whether the body in which the office is held has government powers like relating to releasing money or allotment of land or granting license. Or finally, if whether the office enables the holder to influence by way of patronage, whether the person, let's say an MP, okay, he is also a member of any, let's say any other board of director or something, some other body or organization, whether he being a part of that body or government, can he or she influence its action? That is very, very important and essential. So these are the rulings, and the legal provision, okay, has widened this under Parliament Prevention of Disqualification Act 1959, which lists a wide range of offices that are exempted from disqualification. Okay, and the RPA, that is let me come back here. So the constitutional provision related to this is article number 102 and article number 191 and the RP Act 1951. Okay, so it has barred the person, any person who is holding any other office of profit should be disqualified on this basis. Fine. So it has told that he or she should be disqualified, but it is not told what is an office of profit. That is the issue here repeatedly being discussed. Fine. The next issue is relating to the Rajya Sabha elections. Okay. So recently the Rajya Sabha elections were held last year, and some around 19 seats were filled. So what are the provisions and what are the conditions, requirements? Like, so you will be knowing that it is a permanent body where 1/3 of the members retire every second year, and the members are elected by the members of the state legislative assembly, and the proportional representation and single transferable vote is allowed, and the seats are allocated on the basis of population, which is given in the 4th schedule of the Indian Constitution. So the constitutional provisions, 1, the 4th schedule, which already I told, the article 18, which tells about the total strength of the Rajya Sabha, that is around 250, in which 12 are to be nominated by the president, and the term is to be for 6 years. If the by-election is held, then the person will remain, a person who is elected again will remain for the remainder of the term. Fine. And the qualification, citizen, 30 years of age, not less than 30 years of age minimum, and other qualification if any prescribed by the parliament. Fine. And then some other articles which were in news, article 164, which is relating to the size of the council of ministers, which has been told that it should not exceed 15% of the total members of the legislative assembly. But recently it has been brought up, wherein it was told that in Madhya Pradesh it has exceeded 15%. Okay, and one. Second, the breach of privilege. Breach of privilege provision was brought in the case related to Arnab Goswami. Okay, for making derogatory remarks against the CM. Okay, so this breach of privilege is a violation of any privileges of MPs or MLAs or the members of the houses of state legislature. Okay. Any act that obstructs or impedes either house of the state legislature in its functioning is treated as breach of privilege. Although it was, it was a British thing, but still we continue to use that. Okay. And then there is an appointment of Attorney General for 1 more year. So his provision, his qualification, tenures and everything is given under Article 76. So he is to be qualified as a judge of a Supreme Court, and the term is not fixed. As we have seen just now, I have told it is extended for a year. He holds the office during the pleasure of the President, and he can participate in the discussions of the houses, although he does not have the right to vote. Fine. The next, one of the most important topic is the center-state relation. Often question the static part also. Please go through it very thoroughly. Center-state relation is one of the most important topics for asking questions, whether it is related to interstate council or related to any federal provision or any issue between the center and the state. We'll come back here. So the center-state relation, the first one, the 6th schedule. As you will be knowing, there are certain provisions in the constitution which give special protection to certain states for protecting their socio-economic, cultural nature of those particular states. For example, we have, let's say, Article 371A and 371G. We have from 371 to 371J. Those are the special provisions for 11 states to protect the states' special cultural and economic interest. 371A and G is relating to Nagaland and Mizoram. 371A, G, Nagaland and Mizoram. Fine. So here under, let's say, other article like 371H, the governor has the power to or the special responsibility for protecting the law and order in states which are covered under article, let's say, 371H. Fine. And these are there are certain states like, let's say, Arunachal Pradesh, in which you cannot enter without an inner line permit. This was recently in news because the Arunachal Pradesh has asked the central government to include the Arunachal state under 6th schedule. At present, it is not under the 6th schedule. Fine. So your article 244, okay, which gives or which provides a special system of administration for certain areas which are designated as scheduled areas or tribal areas. Fine. And you have to know that there are certain areas which are regarded as the special or autonomous district regions, like which I have shown, which is shown in the figure here. The advantages of 6th schedule: autonomous district councils, and you will have autonomous regions, and they have certain powers. Okay, so the autonomous district councils have 30 members in total, 26 plus 4 to be nominated, 26 to be elected, and autonomous regions which are divided by the governor among the scheduled tribal population. They have the ADC, Autonomous District Council, have legislative, tax, that is financial power, legislative power, regulatory power and judicial power. Okay, they have the power to make laws, they have the power to even ask the governor's approval to limit application of any particular law in that particular region. They have the power to collect grants and aid from the CFI, Consolidated Fund of India, power to regulate schools, dispensaries, markets and roads, and even maintain the village courts to relating to the tribal cases. Fine. And here some of the areas in inner line permit, as I have already told, that it is nothing but a document which is required for anyone to enter into a particular region, which is limited by ILP, inner line permit. Okay, and permit every for the foreigners, it is mostly ILP is related to the Indians. For the foreigners, every foreigner except the citizens of Bhutan who desire to enter these regions have to obtain a special permit card called as PAP, that is Protected Area Permit or Restricted Area Permit, that is for foreigners. Fine. So here these states like Arunachal, Nagaland and Mizoram have ILP. Recently Manipur also has been included to this list of states with ILP, inner line permits. Fine. So we will move on. So to include, this is the issue which I have told you, that Arunachal Pradesh is demanding to be included here. Okay, and National Commission for Scheduled Tribe is relating to Article 338A. 338 NCSC, 338A is NCST. Okay, and has recommended the UT of Ladakh to be declared as a tribal area under the 6th schedule. Okay, and CAA exempts the 6th schedule areas and inner line permit. Yep, ILP. So some difference between 5th schedule and 6th schedule. 5th schedule is applicable to these states. If you could see here, Andhra, Telangana, Chhattisgarh, Himachal Pradesh, Madhya Pradesh, Gujarat, Rajasthan, Maharashtra and Odisha and Odisha. And 6th schedule is AM, TM, Assam, Meghalaya, Tripura and Mizoram. Fine. So your 5th schedule is created by an act of state legislature. Here ADC is provided by the constitution itself. Okay. And autonomy with respect to 6th schedule is much greater compared to the 5th schedule, although PESA is applicable, that is Panchayat extension to scheduled areas is applicable, and self-governance is supported in 5th schedule areas. Here with respect to the 6th schedule areas, they have Tribal Advisory Council, which also by the name itself it means it has only advisory powers, while the ADC, Autonomous District Councils, have much more powers, as I have shown in the previous image. Fine. Yes. So the next one is the borrowing power of the center and the state. Recently the center has increased the limit for the state from 3% to 5% of the state gross domestic product, gross GDP. Fine. Under Article 292, central government has the power, unrestricted power to raise money even from abroad, while the states cannot raise money from abroad. They can raise only domestically, and there is no limitation per se on the union unless and until it is limited by the act of the parliament. Fine. So the state can borrow upon the consolidated fund of the state. They cannot raise loan if there is an outstanding amount with the central government. Fine. And the next one is relating to the consolidated sinking fund. This was set up in 1999-2000 by the RBI to meet the redemption of the market loans by the state. This is like a reserve fund which was created by the state for amortization of their debt obligations. Okay, where they have to contribute around 1 to 3% of their outstanding annual liabilities, which will be added as a buffer for repayment. Fine. So recently what the center wants the states to, the states want the center to relax the norms relating to the CSF, Consolidated Sinking Fund, primarily due to the COVID pandemic situation. So this fund is maintained outside the consolidated fund in the public account. Fine. So initially 11 states have set up the sinking fund. Later the 12th Finance Commission recommended that all the states should have the sinking fund. Okay, so this was the 1999 RBI sinking fund. This is like a buffer to repay the debt. Fine. Then the Article 370, you will be knowing that it is relating to Jammu and Kashmir, one of the most important, often in news article, which has been abrogated, or you can tell removed, like more than, now it is almost going to be 2 years now. So last year it was in news for 1 year. After it was completing 1 year of abrogation, Article 370 and 335A, which provided for the powers relating to the defining who or what constitute the citizens of Jammu and Kashmir, or who are the residents of Jammu and Kashmir, not the citizens, residents. Okay, fine. So this what was the background in this historical background? 1948, there was a treaty of accession between the ruler of Kashmir and the Indian government. Okay, and we gave support, and we signed an agreement telling that there will be a temporary transitional provision of Article 370. Okay, till Jammu Kashmir is completely integrated into India. So as per the article, the central government needed the state government's concurrence in applying any law except defense, foreign affairs, finance and communication. So such as those and even the state's residents, okay, they lived under a separate set of laws. There was a separate constitution, there was separate flag, everything was almost separate except in these matters. But now it has been abrogated. Okay, as you can see here, there was a presidential order under Article 370 to amend Article 367. Okay, this allowed the expression Constituent Assembly of the State to mean Legislative Assembly of the State, because this was the earlier provision that if it has to be abrogated or changed, then Constituent Assembly of the State has to be created, which is not possible, to recreate the Constituent Assembly which was earlier. So that has been modified to Legislative Assembly of the State. In effect, so it gave the power to amend the Article 370, which allowed the repeal of Article 370. Fine. So, and finally, what we have done under Jammu Kashmir Reorganization Act 2019, we have created Jammu Kashmir Division with the Legislative Assembly and two UTs, UT of Ladakh without a Legislative Assembly. And for the development of Jammu and Kashmir, many schemes have been developed, many steps have been taken. This you can use for your mains answer writing. Fine. This is one more important topic of Interstate Council, which is constituted under Article 263, which was recommended by the Sarkaria Commission and set up by the Presidential Order, which is an executive order. Okay, and this is chaired by the Prime Minister, which consisting of CMs of all states and UTs with Legislative Assembly like Puducherry, and administrators of UTs without a legislature. And there will be 6 central cabinet ministers, including the Home Minister. Okay, there are certain provisions like this specifically mentioned which minister is to be also included. Fine. And at the standing committee to consist of standing committee of the council to consist of chairman as Home Minister and other 5 cabinet ministers. Fine. So this amendment to the Presidential Order 1990 told that the governor can attend in case the state is in under the president rule, because earlier, as we have told, it should be attended by the CMs and administrators. So now that has been modified in 1990, Presidential Order has been modified, and nomination by the chairman of the permanent invitees from among the union ministers are to be nominated. Fine. So this was relating to interstate council, because often one or the other state issue will always be coming up, whether it is related to any let's say water issue or any other issue. So this article, just keep in mind, and with the power of the center to deal with such issues. Right. The next one, aspirational district program, which was created in which was proposed and created, launched in January 2018. Important key points I am focusing, and it is launched in 112 districts out of 739 districts, which even include 35 left-wing extremist districts. And the program is driven by the idea of going beyond the economic measures and going for equitable regional development and cooperative and competitive federalism. Three major themes and three major objectives, or the policy vision, you can tell, or the ideas. Okay? And the themes are 6 themes I have given as HEA, FSB. HEA is health and nutrition, education, agriculture and water resource, financial inclusion, and skill development and basic infrastructure. Health, education, agriculture, finance, skill, and basic infrastructure. Fine. 3 core principles of convergence, C3, convergence, collaboration, and competition. Competition among the districts, collaboration among the citizens and different institutions like of the state government and central government, and convergence of different schemes at the state level. Fine. At the central level, Niti Aayog is the one which is anchoring the program, and the state government, some of them have a dedicated department, some they do not have. Just a committee has been formed in some of the states, and at the district level they have central Prabari officer at the rank of additional secretary or joint secretary to provide the feedback and recommendation to the local committees or based on the local level findings. Fine. and it releases delta ranking for explaining or ranking the districts based on the particular achievements in a particular month. Fine. So this is with respect to your aspirational district program. Then the judicial part. The contempt of court was in news because it was alleged that it was told by the court that the activist, lawyer come activist, Prashant Bhushan was guilty of the contempt of court primarily because he spoke against the judiciary officers or the chief justice. Okay. So this contempt of court has also often been called into whenever there is a criticism, whether it is right or wrong, that is secondary. So when the judiciary is criticized in a manner, it scandalizes the office or it shows disrespect to the dignity or the authority of the court, this often comes in news. Fine. So here, what are the provisions related to this? The constitutional provisions include Article 261, which tells that there should be full faith and credit to be given to the judicial proceedings, and Article 19, which tells that there are reasonable restrictions. Okay, and the Supreme Court or the High Court has the power to punish for the contempt, or the Supreme Court has the power to punish the contempt or seek any person's attendance under Article 142. So it has not been clearly defined in the Constitution what is contempt of court. So that is defined in Contempt of Court Act 1971, which clearly defines what is contempt of court, which means the contempt of court is disobedience of a civil order, or if it is criminal contempt, it is if it is scandalizing, if an act is scandalizing the court or it interferes with the judicial proceeding, then it will be considered as a criminal contempt. Fine. So it can be 6 months imprisonment can be given, or 2,000 rupees fine can be given. Okay, and it should be within 1 year of alleged crime. That is the contempt of court crime. Okay. So what are the exemptions? If it is fair criticism, or if it is accurate reporting, or if it is merely a defamatory attack on judge not intended to interfere in the judicial proceeding. Okay, or these are exemptions. Okay, truth as a valid defense if it is done in public interest, that also can be given as an exemption. Fine. The next one is mechanism to investigate the charges of cases against the Supreme Court judges. Okay, there are 3 different mechanisms as you can see in the table here. Okay. One under Article 124, wherein the Parliament can initiate the proceedings against a judge. Second, in-house proceeding of the Supreme Court. Third, there is a sexual harassment regulation under which there can be the committee, that is gender sensitization and internal complaints committee, which can be constituted. So from Parliament, who can file? It can be 100 members of Lok Sabha or 50 members of Rajya Sabha. Okay, primarily on the charges of misbehavior or incapacity of a judge. Okay, then it should be given to the presiding officer, okay, to whom the complaint must be filed, and the presiding officer can constitute a 3-member committee which can decide on the issue. The 3-member committee will constitute of a Supreme Court judge, Chief Justice of High Court, and a distinguished jurist. Okay, and then in the in-house committee of the Supreme Court, you can clearly see that it can be filed by any person, and it is filed to the CJI, Chief Justice of India, or to the President of India. And CJI is required to determine whether the complaint is frivolous or it is serious. If it is serious, then it can be accepted and an inquiry committee can be created with a judge of the Supreme Court and 2 Chief Justice of other courts. Other high courts, sorry, Chief Justice of other high courts. Fine. Final one, against sexual harassment, complaint can be filed by a woman, and the Gender Sensitization Committee, GSICC, will constitute a 3-member committee to inquire into the complaint. Okay, and if it is found, then recommended actions can be taken up. Fine. The next topic is Lok Adalat, E-Lok Adalat. Lok Adalat, you will be knowing, it is one of the ADR, that is alternate dispute redressal mechanism. That is, other than the judiciary court, there are other mechanisms to solve a case. Okay, instead of burdening the court, there are 4 you can tell 4 ways or 4 mechanisms to solve a case, as you can see in the background image. Arbitration. Okay, arbitration is wherein you bring the parties, both of them together, and they argue their case, and then finally they give an award which will be binding on both the person. Negotiation is a voluntary agreement where they negotiate what can be done. Like let's say for example, some cases like most of the accident cases. Okay, like for example, for a minor injury, they come together, they negotiate. Okay, so this much compensation or anything else can be negotiated. Then conciliation explains the conciliator explains the law. That is what can be reconciliation is explaining, okay, this is how the law is towards you, this is how the law is towards you. They concile the people, reconcile both of them, and it is also a non-binding recommendation. And mediation is like a third person mediating between two people, okay, facilitating negotiation. Okay. And recently what has happened, this platform of e-Lok Adalat, okay, has been organized in 15 states, okay, where there will be a judicial officer who will act as the chairman, and a lawyer and a social worker. 3 of them will be working together to solve the issues, and it is also given a legal status under Legal Services Authorities Act. Okay, so that the case can be solved even at a pre-litigation state, that is before coming to the court itself. So this Lok Adalat degree will be equivalent to the degree of a civil court and will be final. Lok Adalat will be final, and it will be binding on both the parties. And this is important for prelims. Chhattisgarh is the first state in the country to inaugurate state level e-Adalat. Okay, and the Arbitration Council of India, okay, which was created under the Arbitration and Conciliation Act 2019. It is headed by the chairperson, who will be a judge of the Supreme Court, or a chief justice or a judge of the High Court, or an eminent person. Fine. And it will have, apart from chairman, 2 full-time members. Yep. And there has also been there will also be ex officio members like Secretary, Department of Legal, Finance Ministry, Justice, Ministry of Law and Justice, Ministry of Department of Expenditure, and all that. Fine. And there is also one Singapore Convention relating to mediation, which comes into force. Okay, and India is a signatory. India, US, and China are signatories to this Singapore Convention. Fine. So yes, so these are the topics for today. Okay, and I thought of covering few more topics. We have taken more time, so in the next video we'll start from here. We will try to cover as much as possible. So go through these videos repeatedly. You can hear them, just go through the screen. It'll be helpful to remember the mnemonics as well as the shortcuts I will be telling. So I hope this was useful. We will see in the next video. Thank you everyone for watching the video. Kindly subscribe to the video. We'll meet in the next one. Thank you.